Straight ahead on Law and Crime Daily.
He just said, I shot somebody, and then hung up right away.
A friend of accused shooter Kyle Rittenhouse speaks about the moments that followed the deadly Kenosha protest. And a jury is seated in Georgia for the trial of the death of Ahmad Arbery. Brian Buckmire is live on the ground with more. Plus, a shocking claim. Hear from attorneys for the armorer on the set of Rust about what could have led to the fatal shooting. And later,
the defendant is guilty of first-degree murder of a law enforcement officer.
A verdict is in for Markeith Loyd's second murder trial. We discuss more on the next steps. Pulling in for Brian Buckmire while he is on assignment in Georgia covering the trial for the death of Ahmad Arbery. Co-host Terry Austin also joins me today. We enter into day 2 of testimony in Wisconsin for the accused Kenosha shooter Kyle Rittenhouse. 18-year-old Rittenhouse faces multiple charges, including first-degree reckless homicide, intentional homicide, and attempted homicide. The charges stem from the 2020 Kenosha riots, following the shooting of Jacob Blake, a black man shot by a white police officer. Prosecutors say that the teenager shot 3 people during the protests. Joseph Rosenbaum and Anthony Huber were killed. Gage Grosskreutz was wounded. Rittenhouse says he acted in self-defense. The prosecution's first witness was Dominic Black, a friend of the defendant who accompanied him the evening of the riots. Black is also the person who purchased the gun for Rittenhouse prior to the incident. He also faces criminal charges. On direct examination, Black described Rittenhouse in the moments following the shooting.
He just said, I shot somebody, and then hung up right away. He was freaking out. He was really scared. He was pale, sweating a lot. You could tell he was just scared.
Did he say anything?
He wasn't really talking. He just said he had to do it. It was self-defense. People are trying to hurt him.
Did he ever say to you that someone was trying to attack him with a gun?
No.
Did he ever say to you that someone was trying to attack him with a knife?
No.
Did he ever say to you that anyone was trying to attack him with any sort of weapon?
No.
On cross, the defense attorney questioned Black about his decision to take guns to the protests in the first place.
You wanted a gun?
Personally, for myself, yes.
You had no objection or voiced no objection to Kyle, your brother, having the gun, correct?
It wasn't a thought in my mind.
Well, he walks out of the house with an AR-15, and you don't say boo, correct?
I didn't say anything, correct?
And you had the ability to speak.
Yes.
If you wanted to object, you could have said something to Kyle, correct?
Yes, I could have.
And you didn't.
No.
Because you wanted him to have the gun for protection.
Not that reason exactly.
You wanted a gun for protection.
Yes.
Let's bring back our co-host Terry Austin and our guest today, legal analyst Dina Dahl, to break this down. Dina, this witness had a lot to say about the night of the shooting and what led up to it. Do you think that he was more helpful to the prosecution or to the defense with his testimony?
He was not all that useful to either, except for the fact that he laid out the fact to the jury that, one, he was illegally had this gun. He was underage. And, there's a reason why we have laws for underage, because we don't believe they have the judgment, which leads into this here. Did he have the correct judgment in shooting those people? And it also kind of goes to the fact that there was a group of them that went into the city with the purpose of, quote, defending these businesses. So the prosecution needed that to lay out the story. But the defense was also able to get some things in that were helpful to them, such as the fact that he himself also believed he needed to have a gun. But I think the prosecution did a great job of also saying nobody else killed anybody that night except for the defendant.
Yeah. Now, Terry, let me ask you, Dominic Black was the first witness called to the stand. Why do you think the prosecution chose him first?
Well, I think he was chosen first because he was the one person who could establish that timeline of the events that Dina was just talking about. He was with the defendant before, during, and after the event. And he, frankly, in my humble opinion, at his young age, is fairly well-spoken. He came across as very calm. He came across as very credible. And he is the best friend of Kyle Rittenhouse. He dated Kyle's sister, and yet he testified against Kyle. So I think that gave him a lot of credibility as far as the jury is concerned. And the other thing I'll say is he was fair, and he was, as far as both the prosecution and the defense was concerned, he was deferential to both of them. So I think that was good.
Yeah, we're going to wait and see what happens in this trial, but still ahead here on Law and Crime Daily, who is to blame for the deadly shooting on the Rust movie set? Hear from the attorneys of Hannah Gutierrez Reid, the movie's armorer. But first, jury selection is nearing an end in Georgia. Our own Brian Buckmire is live with more on the trial.
It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmad Arbery, gunned down in broad daylight. The three men charged will now stand trial. For live gavel-to-gavel coverage of the trial, subscribe to Law and Crime on YouTubeTV today.
Welcome back to Law and Crime Daily. And after more than 3 weeks, the magic number has finally been reached for jurors in Georgia in the trial for the death of Ahmad Arbery. Attorneys will select a jury and alternates from a final pool of 65. They will decide the fate of Gregory and Travis McMichael and William Roddy Bryan, who all face charges of malice murder, felony murder, and aggravated assault for the shooting of 25-year-old jogger Ahmad Arbery. Prosecutors say that the father and son, Gregory and Travis McMichael, followed Arbery in their pickup truck as he ran near his home in Georgia back in February of 2020. Travis McMichael shot and killed Arbery, claiming self-defense. Bryan followed along in his own vehicle, recording this on his phone. Opening statements are set for Thursday morning. Joining us now is our very own Brian Buckmire, who is live on the ground in Georgia outside the courthouse. Brian, what are your main takeaways from court today in Georgia?
Imran, it started fast and furious from this morning, where we had 65 potential jurors come in, and then just a few moments later, they were walked out of the court because Kevin Goff, the attorney for William Bryan, brought up multiple issues. Some of the more notable ones is that he said that one of the jurors found out there was a TikTok account and questioned them about that. Now, he questioned that person to the point that almost seemed like a cross-examination, and as they walked off, that juror shook their head and was disqualified because the judge said they couldn't be impartial to the defendant. Now, it also brought up the Bubba argument that ended up just ending off with them saying, I simply want the questionnaires to be saved. But this afternoon, all things hit the roof, where 12 African-American juries made it to the first round, but 11 of them were struck by the defense, and arguments about a Batson challenge that the defense was eliminating them based on race grew in a large volume in this case. Now, arguments by Goff appear to slow down proceedings, something that the attorney for Wanda Cooper Jones, Lee Merritt, commented on.
Goff is doing a bit of grandstanding. He's enjoying the limelight a little too much. This is serious. This is a murder trial. His client participated in the murder of my client's son. So a Bubba motion, or whatever he wants to call it, is neither a legal remedy. It's not entertaining. It's not something that we want to continue to discuss. We want to get to the trial.
Now, Brian, I was waiting for a Batson challenge during this jury selection, and here it is. Can you explain to our viewers what is a Batson challenge?
So, Imran, there are different types of challenges. You can have what's called a for-cause challenge. A person can't follow the rules of the court, for example, or has an implicit bias in the case. There's also what's called peremptory challenges, where the defense or prosecution can simply eliminate a person just because they don't think they're the right person. But if you use that peremptory challenge and the other side believes eliminating people based on race, gender, or any kind of protected class, you can make a challenge to that peremptory challenge and say that you're eliminating people not because they can't follow the law or the rules of the court, but based on this occasion on race.
And what were some of the arguments that both the defense and the prosecution made?
So it's interesting. For the defense, they're treating this as a second bite of the apple, trying to eliminate those African-American jurors who said things that they didn't like, but the judge still kept them on because at the end of the day, they said that even if they have some sort of bias, as many of the potential juries said, that they can put those aside and listen to the rules of the court and the judge's instructions. The prosecution on the other side is saying that both white, black, brown, and in every race under the color said the exact same thing, that they have certain preconceived notions about the case, but can put those aside, but only the African-American jurors were eliminated, while the white jurors will not.
Brian, thank you for your great reporting. Coming up on Law and Crime Daily, a Florida jury comes to a speedy verdict in Markeith Loyd's second murder trial. What was their decision? Coming up shortly. Plus, The attorneys for the Rust movie armorer Hannah Gutierrez Reid speaks out about what they think happened the day of the fatal incident. Attorneys for the armorer on the set of Rust are defending their client in a new interview and suggest someone may have wanted to sabotage the set by bringing in live ammunition. Law&Crime's Anjanette Levy is here with more on what lawyers are saying. Anjanette?
Imran, Hannah Gutierrez Reid is that 24-year-old armorer who was in charge of the firearms on the set. And get this, her lawyers actually suggested that some of the crew members may have been unhappy with the working conditions, and that's possibly how that live ammo made it onto the set.
The person who put the live round in the box of dummy rounds had to have the purpose of sabotaging this set.
That suggestion was made by attorneys for Hannah Gutierrez Reid, speaking to the Today Show on NBC Wednesday morning. Gutierrez Reid loaded the gun used by Alec Baldwin, according to her lawyers, but they say it was left unattended for 2 hours that day. Jason Bowles says Gutierrez Reid loaded the gun with cartridges that came from a box of dummies.
She loaded rounds from that box into the handgun, only later to find out and she had no idea. She inspected the rounds, that there was a live round. Now, we don't know, however, whether that live round came from that box. We're assuming it did.
The facts are in dispute. The lawyers claim Gutierrez Reid gave the gun to Assistant Director Dave Halls and showed him the drum to inspect. Halls' lawyer has suggested he didn't have the weapon, but a search warrant affidavit quotes Halls as saying he should have checked the revolver before handing it to Baldwin. Alec Baldwin fired the gun last month as he practiced a cross-draw, killing cinematographer Helena Hutchins and wounding director Joel Souza. Bobby Chacon is a technical advisor on TV shows and explains how firearms should be handled on sets.
In my opinion, and it's good practice, I believe, to have the armorer deal directly with the cast member, no middleman.
And Alec Baldwin is actually disputing all of these claims that the working conditions on the set were so poor that people were walking away and upset about it. He reposted on Instagram one of the crew members' Facebook posts, and Therese Davis used a curse word that begins with bull to actually describe these complaints about the working conditions. She also went on to say that there were accidental discharges on the set, and she said the guns were checked immediately and that those discharges are more common than you would think. Imran?
Okay, so let's break this down, everyone. Dina, I'm going to start with you. With the suggestion of sabotage here, is it possible that some criminal charges may be coming down the line? And how viable do you think that these charges would be?
It definitely raises, there could be criminal charges even if there is not this sabotage, because there could be some recklessness on their part. But the implication that this was intentional, that's what the sabotage claim is, that somebody intentionally put a real bullet among the bullets, could then raise the criminal charge to some sort of intentional homicide. I mean, we are very much in the beginning of this investigation. It's, common for an attorney, he's really coming out to try to defend the reputation of his client, who's had a lot of press reports kind of putting the blame on her, and he's coming out to defend her here. But we still have to see the facts.
Yeah, Terry, how might this new information about sabotage shift the focus of the investigation as it's currently underway?
Well, it certainly will take it up a notch. It's going to shift from that criminal or civil liability dealing with negligence to criminal liability dealing with intent and some sort of motive. As Anjanette said in her package, the implication here is that someone wanted to sabotage the whole set. And if that's the case, they're going to have to look for people who might have these grudges, and essentially everyone will be under suspicion.
Yeah, Anjanette, these are somewhat bold, a suggestion to say that this was sabotage. It's a bold thing to come out and come forward and say that. Did Hannah Gutierrez Reid's lawyers offer anything to back up their claims of that sabotage?
Yeah, it is a rather bold claim. I would agree with you on that, Imran. And no, they didn't. They said, they don't even really have a working theory here. They're still working on gathering facts. And they discussed how, the FBI and the Santa Fe County Sheriff's Office detectives would be investigating this and trying to determine how that live ammo made it on set. Obviously, as the armorer on the set, Gutierrez Reid would be responsible for looking over those cartridges because they are different from actual projectiles when loading that gun.
Yeah, I think we're all going to be watching how this investigation unfolds. Thank you. When we come back, the verdict is in for Markeith Loyd in his second murder trial. We'll take you
as to count 1 of the charge. The defendant is guilty of first-degree murder of a law enforcement officer.
Well, welcome back. And the verdict is in for Markeith Loyd, as you just saw there. Jurors deliberated for approximately 5 hours before finding him guilty on all counts in the murder of Lieutenant Deborah Clayton. Lloyd shot Clayton in 2017 as she tried to arrest him for the murder of his pregnant ex-girlfriend, Shauday Dixon. Lloyd is serving a life sentence for that murder. Lloyd faces the possibility of the death penalty in Clayton's murder. He spent more than 3 hours on the stand testifying that he feared for his life and acted in self-defense. In closing arguments, the state suggested that Lloyd always had a motivation to kill, pointing out evidence from a Facebook post. The penalty phase begins Saturday.
I'd rather die than live my life in a cell. It is not a secret there's been evidence that Mr. Lloyd was in prison up until 2014, and he's made it clear through his Facebook post he was not going back. Lieutenant Clayton's goal, her only goal on the morning of January 9th, was to bring him into custody. And that was one of the few things he would simply not allow. The defendant had a motivation to kill.
And in the defense's closing arguments, attorney Terrence Leneman maintained that the argument that his client was in fear for his life and had no choice but to shoot Clayton.
And he's going to defend himself. Then the minute that he turns around and sees her with a gun, he's not going to stop firing until she doesn't have a gun or he's not in danger anymore. Once the first shot is fired and now he's reacting, and she still has her gun in her hand, and she's still firing, in a matter of seconds, what does the state want to happen? For him to stop and run away while she has a gun pointed at him? They're still firing at each other. He could not stop in his tracks. He could not walk away.
And after closings concluded and outside the presence of the jury, the defendant went off in the courtroom about why he thinks his trial was unfair.
Is there anything else that you asked your attorneys to say?
It's a bunch of stuff. It's a bunch of stuff.
Do you want to list it now?
No, because I'm upset right now, and I'm about to can't even talk no more.
All right.
Because they think they know everything.
Mr. Watch your language. Take a deep breath and calm down.
They slow. They think they're so smart, but they're not. You're not more intelligent than me.
Is there any other than the
them or them?
Mr. Lloyd, focus. Mr. Lloyd, you need to look at me and focus.
Okay, let's break this down. Dina, I'm going to start with you. The jury deliberated for close to 5 hours over the course of 2 days. Were you surprised with this rather speedy verdict and the outcome?
No, the defense did the best job they could, but the evidence was overwhelming. There was the video footage, the fact that he was a fugitive, having been convicted of murder. She was doing her job and he killed her. So I'm not surprised. I think that some of the mental health issues that were brought up may go into mitigating whether or not he receives concurrent life in prison or the death penalty. It might help him avoid the death penalty, but certainly not enough to help him avoid a conviction.
Yeah, certainly swift justice. Now, Terry, the death penalty, the only issue which remains is whether Lloyd is going to get the death penalty. What are your thoughts on that?
Well, I think if any case gets the death penalty, it will be this case. We are in the state of Florida, and the aggravating factors there are numerous that apply to this case. He shot and killed a law enforcement officer. He's a prior felon. He was trying to avoid custody. This was a heinous crime. It was great risk to others because there were others in that parking lot at Walmart. So I do believe that he might get the death penalty here. The only thing, and Dina mentioned this, that could save him is the fact he may have that mental illness. And remember, Imran, the state of Florida does have a history of putting people to death. There are currently 305 prisoners on Prison Row, and they've executed 99 since 1976.
Yeah, we will be watching that sentencing phase indeed. So thank you, everyone, for joining us here on the Law and Crime Daily. And we're going to be seeing you next time to discuss justice in America and court cases across the country.